this one in Panama City. I went to it when I was working at claims there.
Good afternoon.
Chair.
Good to see you.
Today's meeting of the Municipal Code Enforcement Board is called to order on February 25th, 2026. Welcome, everyone. Please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Please be seated. Agendas of today's meeting are on the wall at the entrance to chambers. Please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council. We serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, the violation, and then affirmative relief. Formal rules of evidence do not apply. Each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak to rise and be sworn in by the clerk.
If any of you are going to be speaking during the meeting, I need you to rise. Thank you. Do you swear or affirm to tell the truth throughout your entire testimony? Thank you.
Thank you. The clerk has requested that we proceed out of order and take a specific item first before our new business. And this is on page 5 of the agenda. First item 5.1, case 16-24. Consider request by petitioners, Resi Prestige Worldwide LLC at 910 Ingman Street, to reduce the fine regarding the abandoned building, and if approved, issue an order that specifies a fine that includes administration costs and establishes a date payable, or the lien will revert to its original amount.
Good afternoon, Board. Inspector Dixon, City Clearwater Code Compliance Office. To just give you a little background on this. The property was written up approximately 2 years ago, and it was found in violation of this board for an abandoned building. It's been accruing liens ever since. The family couldn't maintain the property, so an outside LLC came in to purchase the property, and it was found that there were multiple names on the title and the deed, and some of them had passed away. So they took on the task of going through a lot of probate over the last 2 years to get it to where it's in their name. And now they're under contract to sell to Habitat for Humanity. So we would support reducing those liens down in administrative costs.
Thank you.
And the property's been maintained by the LLC ever since they've gotten involved.
Thank you, Inspector. So the question I have is, what is the requested lien reduction amount or the administrative fees? What is that number?
The administrative fees total $1,027.20.
That's 102727?
1027.20.
There is somebody, a representative from Habitat for Humanity here, if you have any questions for them.
What date are you requesting? Is there a date?
No,
No.
just a lien reduction.
This is just a lien reduction request.
Yes.
Madam Clerk, it's appropriate to have the, if there's somebody here to represent, to speak. Is there anyone here to speak on this case? Please come forward, sir. Could you state your name and address to the clerk, please?
Yes, sir. Cesar Figueredo with Habitat for Humanity on 14010 Roosevelt Boulevard in Clearwater.
Okay.
So the property in question is 910 Ingman. This property, we were originally under contract 2 years ago prior to the probates. Once we realized that there were probates on it, we kind of let them handle that at that point, and now they've come back to us to purchase the property again. Right now, we are in a due diligence period and are requesting for the lien reduction. At this time, once closing of the property occurs, we are good to begin with demolition and making sure that the property is given to homeowners. Absolutely. Does anyone have any questions?
Word?
How long is the due diligence period?
So right now, the diligence period is until March 6th. Closing is set for March 13th.
Thank you.
Yes, ma'am?
All right, any other questions?
No.
All right. And what is the city's position on this?
I believe Greg
Inspector?
said the city would support. the
Mr.
reduction.
Chair, if I may, we support the request. As was stated, I would just suggest that we put a payable within, it sounds like 30 days would be sufficient for them to close and pay. That way, if something happens and it doesn't close, then it would revert back and the board can address this again whenever it comes back around, if there's a new buyer or something else happens.
Okay.
My suggestion.
Okay. And is that 30-day period
Yes, sir.
good for you?
Yes,
All
sir.
right.
Mr. Chairman, I'll move and make a motion.
Please.
I move to enter an order reducing the amount of the lien to administrative costs of $1,027.20. Is that correct?
Yes.
Payable within 30 days, or the lien will revert to its original amount.
Second.
All in favor?
Aye.
All opposed? Motion passes.
Thank you for your time.
Thank you.
We'll revert back to our typical schedule of new business. And prior to that, we will, bear with me a moment. Our next order of business is to review and approve the minutes of last month's meeting. May I have a motion to approve the minutes?
Motion to approve.
May I have a second?
Second.
All right. All in favor?
Aye.
All opposed? Motion passes. Next on the agenda are the new business items. Our first case is 3.1, continued from December, case 190-25. Find respondents Marco Victorino and Wee Wee Yang Victorino at 1768 Bentley Street in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak to this case?
Nope.
All right. Inspector?
Good afternoon, Code Board. I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 1768 Bentley Street, case 190-25. We have one violation for permits required on this property. We have multiple notices sent, the first one being December of 2022, the final of June 2025. We have multiple signatures for the notice. Oh, excuse me. This is going to be just south of Sunset Point and west of Keene Road. It is a single-family resident. It is in reference to the pavers that were laid on the property. And I have had contact with the owner. That is what it originally used to look like. And he did come in to get a permit, but it is going to require that he put in the FLS, a variance, because of the extension and where those pavers lie. That is the reason I gave the continuance, but he has not come in. I mean, he attempted to come in, but it was only last week, which would be impossible to get that approved. It would need to be met in the next meeting that they hold for any variances. So at this time, I just feel it's best that I bring it to the board so we can get a solid date for him to come into compliance. It can be met by obtaining an issued permit and completing said permit, or he can remove the pavers and restore back to its original state. So I'm requesting compliance on or before April 25th to obtain an issued permit and 3 months from issuance to complete said permit. The dates are a little different than what I normally ask for because I know that it's going to take time for, if he does comply and come in for the FLS, it will need to be heard in their meetings and hopefully get approved. And then it's already done, so 3 months would be sufficient to complete it.
Very good. Board, do you have any questions? How many times have you had contact from the owner?
Just glancing at 3 different times since I took over the case, and I've, guided him with exactly what needed to happen and who he needed to speak with, and I feel I gave him ample time to do that, continuing all the way from December to today, and we still have no progress, so
Okay,
So we're talking almost 3 months or?
that is correct.
Yeah,
all right. All right,
first motion.
please.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? Motion passes. Have a second motion, please.
I move to enter an order requiring the respondent to correct the violations on or before April the 25th, 2026. Okay. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
And a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Next case, 3.2 has been withdrawn. Number 3.3 has been withdrawn. 3.4 is continued from January 28th, 2026. And it looks like this is going to be continued to March 25th. So we'll let that one move
Okay.
on until March. Next case would be 3.5, case 23-26. Find respondents Connor Petrin at 3804 Brigadoon Circle in violation of code for exterior surfaces, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? No? All right. Inspector, you have the floor.
Actually, this case is supposed to be continued as well. Or it should be. Mr. Petron spoke to him on the phone, and he has a desire to be here, so we would like a continuance.
All right. Well, board, any objections?
No.
All right, this case will be continued until the March meeting, Inspector?
Yes, that's correct.
All right. Thank you.
March 25th, Mr. Chairman.
Thank you. So this case will be continued until March 25th. Moving on, number 3.6, is it continued?
Did we get a motion to continue it?
I'm sorry?
No.
Was there a motion to continue that item?
Nope, but we can do one.
Yeah, thank you.
All right, can I have a motion to continue case 23-26? Anybody?
Motion to continue, Mr.
Thank you.
Chairman.
All right, may I have a second?
Second.
All right, all in favor?
Aye.
All opposed? Motion carries. Thank you. Next case, 3.6 is going to be continued until March 25th. Case 3.7, or number 3.7, case 25-26, find respondents Tripod Clearwater LLC at 400 Coronado Drive in violation of code for prohibited signage, and issue an order with the compliance deadline and fine if compliance is not met.
Stephen Burkhardt, Sign Inspector for City of Clearwater. Good afternoon, Board. The case is in compliance. I'm just asking the Board for a declaration of violation.
All right. May I have a declaration of violation?
I note to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may,
Thank you.
oh, I wasn't on. Do you want me to start over?
Please, make sure it's on the record. Thank
I
you.
move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
May I have a second?
Second.
All right, all in favor?
Aye.
All opposed? Motion carries. Moving on to case, or number 3.8, case 26-26, fine respondent City Square LLC at 522 Cleveland in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. You're here to speak on this case, sir?
Good afternoon, council. My name is Michael Lignos. I'm here on behalf of the respondent, City Square LLC. I'm an attorney. I have, may I start, or is there someone else who'd like to?
Well, first we need to find out
Yeah.
if it's a met or denies.
Excuse me, sir, I didn't hear you.
Yes, sir. Your relationship, you're the attorney for the property?
For the property, yes, for City Square LLC. The tenant is here as well, who's been working to, Mr. Tello is here as well, and he can address any questions you all have about the technical aspects of it. But
Understood.
I'd like to say that there was a pending application that was submitted in January.
I'm going to interrupt you if you don't
Yes, sir.
mind, because we're going to follow our typical procedure,
Of
and
course,
then you'll
sir.
have plenty of an opportunity to speak. The first question we have is do you admit or deny the violation?
Admit.
Very good. Can I get a motion, please?
I'll move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
Second. All in favor?
Aye.
All opposed? Motion carries. I believe we would have the inspector speak next and give us the facts of the case, and then we'll have you respond, sir.
Yes, sir.
Thank you.
Good afternoon, Co-Board. Inspector Kat Reese with the City of Clearwater for case 26-26. We have one violation here for a permit that was permit for a humidor and a bar that was installed on the property without a permit. This case did begin in October of 2023. That was the first notice of violation sent, and the final was sent December of 2025. I did post the property December 30th of 2025. And this is going to be right on Cleveland Street, just east of North Fort Harrison. It's, just to give you a good reference, it's right next to Nash Keys, just east of that, if that helps. This is posting of on the property. And this is what the, when it was the wine establishment, this is what the store did look like. And that was what the bar used to look like as well. And that's also from when it was Pour Yours. And this is the Captain's Cigar Lounge when it was open. And that is the new bar that was there. And to the rear over here, you'll see the humidor. And this is a close-up of the bar, which you can see has the taps there, which requires plumbing on that. And the humidor. And then it's just a couple more pictures. This also shows the electric that's in the humidor as well. So compliance can be met by obtaining an issued permit and completing said permit. We're requesting compliance by obtaining a permit on or before March 25th, 2026, and completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist. Okay? And just to give some background, I have been speaking with the attorney. I have also spoke with the property owner. She is very eager to have her tenant comply, but, you know, she can only do so much. The tenant did apply for a permit. It is currently in a received status, which means that it's basically in limbo. They just applied for a permit, nothing else was submitted along with that to process that, anything. There's absolutely no documents attached to it, which is why I feel that it was just best to come in today, because this has been going on for quite some time. We've had previous inspectors have noted the case, that they've had, you know, conversations with the property owner, with the tenant, and here we are in 2026, you know, still in the same situation, so.
Inspector, just a moment. I have a question.
Yes, sir.
Before it was a wine bar, correct?
Yes, sir.
Does that license carry over to this bar?
I don't deal with licenses, but I don't believe it does.
All right, is this bar, is it going to be wine or beer or liquor or what?
Right now, it's just a vacant, but the work was done, so whether or not it's
Okay.
opened or not, it
Okay.
still needs to be permitted, so that way whoever takes, if someone else takes over, they're not liable for the work that they didn't do. We just want to ensure it gets permitted.
So the permit is just for building the bar?
Correct, and the
Okay.
humidor.
All right, and the humidor. Okay, thank you.
Can you give us a bit of an idea? I mean, what kind of work was done? It was the humidor,
So
and the bar was changed?
Yeah, so if we can go back to the pictures.
Yeah.
I'll go specifically to the bar itself. So this bar, you could see, it was just a tabletop bar. There was no taps there.
Gotcha.
So it had to have the plumbing, let me go back to this one. Because there are now the taps on both ends of these bars, which is gonna require the plumbing permit. The same with the humidor, that needs to be permitted altogether, as well as the electric that's inside there.
Okay.
So it will require plumbing, electric, and the structural of the humidor.
Thank you.
Thank you, Kevin.
Thank you for your
You're up,
patience.
sir.
Would you like to? Okay.
Yes,
Step
this
it.
is Mr. Tello. He is the tenant in the property.
Okay.
He's running the business, and he can answer any
Yeah.
technical questions that
All
you
right.
might have.
So if
Tell
you,
us about this.
so I own, I'm 520, I'm Nash Keys, and this is our secondary project. Originally it was Captain's, and now we're trying to, we closed it down, trying to revamp it and do everything the right way, because we know the other permits were pending, and so forth. If you look back at the Pour Yours pics, Pour Yours is a self-pour wine establishment. That wine establishment did not require any plumbing because the taps were just self-serving from the thing. That's the same function as those plumbing. The reason why we've had so many complications with the permitting process is because we're getting a lot of contradicting answers back from the permitting department. For example, the case upstairs, right here, says that those require plumbing. They are not plumbing at all. They're just a refrigerator that attaches a self-tap on top, and it goes in the bottom. So it's the same process as Pour Yours self-pour wine, hence no plumbing. The bar was extended. The bar was there previously, but the bar was extended. And we have an ADA compliant bar. Since we built it out for Nash Keys, we understood there was an ADA compliant bar necessary, but we did build it out. The ADA bar is a different sizes, obviously. The humidor, we had a outside contractor file permits for the revamping of it, but I don't think he filed the permit correctly for the humidor. Again, there's complications on that. We were told that there was an HVAC issue with that as well. Again, it does not have HVAC. I think the inspector is getting confused with the picture above, which is a cigar filtration or smoke filtration system, which is not an HVAC and does not require plumbing again. I think that's where the issues and the confusion is coming back. We have a chief of staff, Shelley, here, who has documentation of all the emails going back and forth. I've had a personal meeting with the fire department, as well as Dana Root, I believe, and 5 other members, trying to get this up and going recently, and we were trying to work on things exactly what to do. I'm doing the best possible. I love Clearwater. I've invested my life and moved down my family here. You guys know me from Nash Keys. I believe in this town, and it's hard to see the process that it takes to get these things open. You guys were with me during the Nash Keys process. That took me about 2 years just to get the permits. So it's an ongoing battle. I know there's room for improvement in all areas. I'm just here to say that I'm happy and willing to do whatever I need to take to get this place open. Because every week we're not open, it's substantial losses to our establishment, and we've had to close down our Prelude location because of the losses in, they were tied up in bureaucracy, let's say, with the outdoor permits and stuff. I want to see this town grow. I'm willing to do whatever it takes, even if it means taking down that humidor and just having the place open. I'm just here to say that I'm willing to work and want to get this thing done.
There seems to be some discrepancy regarding the requirement for permits. I saw Dana Root
Yes.
offer, stand up. Maybe he had something he wanted to offer, or perhaps you can.
So I apologize, I
enlighten
did
us.
misspeak on the plumbing. He is correct about that, but it does require the electric. That is where, and I apologize, it's very difficult when I'm not taking these cases on from the beginning and just, looking through things, so my apologies for that, sir.
Does not require electrical. It's a self-tap. If you guys ever use
Well-
a party check, also does not require electrical.
We're talking about the electrical inside the humidor?
The electrical humidor was an existing, it doesn't.
Sorry, I just need you at the microphone
Sorry.
to pick up the record.
The bar tap does not require electrical. The humidor is electrical that was existing there prior, but I did pull it out. That wasn't me, but that was the contractor, so that I do understand.
Well, I do think regardless of the work that was done, it still will require plans to be reviewed, and that's the point of the plans, to get the permit. So I think at this point, we just need to set a compliance date for the permit and allow him to go through the process of going through the permit technicians and the building, reviewers for the rest of it. But it is in fact in violation, as admitted, so
Understood.
that should be the focus, I believe.
Understood.
Counselor might want to say something, Mr. Chairman.
Do you have anything else to offer?
Sir, I read the recommendation. We would be very happy to accept that if no, it's up to the board, but we have no objection to that being
I'll say, okay.
Sir, if you could please go to the microphone.
I'm
Just
sorry.
The
Of
audio
course.
technician was.
Yes, I just said that the recommendation seems very reasonable under the circumstances, and we have been, they have been trying to work with the inspectors and with the planning board, and I think that's fair, and I think there won't be a problem in getting that done within the time period that the inspectors have suggested.
Great, thank you.
Thank you, sir.
Catherine, anything else you'd like to say?
No, sir?
Okay.
All right, and you're asking for compliance by March 25th?
That
Like
is
a
correct.
permit by
Yes.
March 25th?
Yes.
Okay.
And that's including a plan set?
Yes, it is. They will have to have an issued permit by that date.
Yeah. All right, and if,
But you're sorry,
go ahead.
but you're requiring a plan set to be submitted with the permit?
Well, in order to obtain a permit, it would require the plans, and drawings of what was done. But that is something, I don't want to speak too much on the permit technicians' positions, but that is
No.
part of the general permit process.
But my concern is that there's confusion as to electrical, plumbing, and everything else. So they don't even know what type of permits they're putting in for. So I think we should just continue this and let them get that exactly sorted out.
I think it's, the crux of it is what specifically is required for permit, and I think that's a conversation for the owner to have with the building department and get clarity on that. I will tell you that if there's no structural or no significant changes to the property, based on what I've seen, I don't see those, that I doubt seriously whether they're going to incur or have to employ an architect and get that deep into it. So I would think that if they get with the building department, that I would tend to think that March 26th is a good date, and
Yeah,
if
that's
the
almost 6
problem
weeks.
arises, they can always come back to the board. And that, the inspector has the latitude on that too. The code compliance
That is
officer has the latitude. She will know whether or not they are, what they're doing and how that's progressing. Any other questions? All right, can I get a motion?
move to enter an order requiring the respondent to correct the violations on or before March 26th, which means having an approved permit in this case. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Before we take a vote, was it the 25th or 26th?
The 25th.
That's what I thought. You said the 26th.
Yeah.
Okay, I'd like to change that to the 25th then.
So we'll correct that in the record to the 25th. Can I get a second?
Second.
All in favor?
Aye.
All opposed? The motion passes. Thank you, sir.
Thank you.
Moving on to number 3.9, case 27-26, find respondents proactive property management at 2801 Brigadoon Circle in violation of code for permits, and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on that case? Inspector Reese, you have the floor.
Okay, I have spoke with the property owner for this, but before we get into that case, I'm gonna do something a little different here with all the Brigadoon cases that we will have pending. I have gone ahead and just made a general slideshow, so you could have a full understanding of what's gonna happen here with permits. So again, I'm Catherine Reese, Inspector with the City of Clearwater. This is just a GIS map, which shows, this is Fairwood Avenue, so entering into Brigadoon would be Brigadoon Drive. So some addresses you're gonna see are gonna have Brigadoon Drive, and then the remainder in the middle here will be Brigadoon Circle. So it just clear that up, because there seems to be confusion with
We
that.
are well familiar with Brigadoon.
Okay. So I did go ahead and put in a couple of examples of successful permits that have been pulled for people who have come in compliance, whether it was for pavers or for patios. So for this one, I believe, I can't see with my, I have to look down here. Okay. So this is going to be for pavers that were laid on the property. As you can see, it's going well beyond their property lines. And we do have a resolution for that, so that they are able to keep their pavers as long as it gets permitted. So, and this is another example of pavers on the side of another property, also successfully permitted. And this is going to be an example of one for patio enclosures, which you'll see today as well. And as you can see, most of the properties, generally speaking, only have a little over 3 feet past their entryway from either side of, from the back end of their property. They only have that 3 feet. Anything beyond that would be the common area for HOA. And this is also just another example. This is a patio here that was extended well beyond their property line. The city has worked with the HOA. I have attended HOA meetings. I have dealt with the HOA attorney. The city has agreed to use this form that residents will need to pull and get notarized that they do with their HOA, that is not with us. They bring this in and they are able to pull the permit as the resident of their property to be able to keep what they have beyond their property line. So this is just, right, as of today, we have 69 successful permits that have been pulled after the fact. The city is not charging any of the residents 3 times the fee as we normally would for work done without a permit. Given how long this has, how long ago most of this work was done and the amount of cases that are there, our ultimate goal is to let the whole community come in compliance. So with that, I will go ahead and go to our case here. And because of the, depending on where the work was, if it is completely out of their property line or appears to be out of their property line, we legally did have to send those notices to the HOA, which are labeled as 4400 Brigadoon Circle. So you will see notices that were sent to that address, but we are allowing the permits to be pulled under the property itself. So for this case, would be 2801 And this is gonna be for case 27-26. And that is, I'm sorry, and that is gonna be in reference to 2801 Brigadoon Drive. But it is ultimately the HOA at 4400 Brigadoon Circle if they did not come in compliance.
Is that who the notices went to start with?
The notices did go to the HOA, correct?
Okay.
I have a question.
Yes, sir.
Why are there so many violations in this development?
This was complaint-driven from a resident that lives there. She was, just wanted to complain, make a formal complaint about all the violations happening. She was concerned with her property value, and
But was it the developer, or was it each individual homeowner's done work and had a
That-
complaint?
so, yes and no. There was for the patio enclosures, it appears that it was done by the same contractor over 20 years ago. I have done a lot of digging. He has unfortunately passed away. So each resident is having to find a general contractor to pull an after-the-fact permit. So there is a contractor that lives in the residence that has been pulling majority of those permits, as well as another contractor. I haven't seen much else, any other contractors really being used, but they do have their choice, as anyone does, to pull with whatever GC they'd like. So,
Is it, I'm a little confused. Is there a time limit for violations?
So I have been working with every single resident in Brigadoon. So if I'm bringing it to the board, it is because I have given reasonable time and communication has either never happened or it just stopped and and nothing has been permitted or changed, so.
I was gonna ask you, has the board ever been cooperative with you when you talk?
Absolutely,
Okay.
yes.
Did that answer your question, or were you asking about a statute
I
of
thought,
limitations?
I can
could you
chime in.
clarify, because I
Yes,
thought
Yes,
if
Mr.
work
Chair.
was
Yeah.
I know
completed,
the
then.
answer, but we'll let the council.
There's actually, there's case law on this, because every day that the violation exists is considered new. The courts have said that statute of limitations does not apply to code violations. So the fact that it's unpermitted work, it's encroaching beyond the property lines, that, each day that exists constitutes a new violation. So we do try to be as flexible as we can for people. A lot of these people kind of bought something that they bought a problem that they didn't know that they bought. So we are very sympathetic to that, and we've been slow rolling this train here as much as we can. But in terms of your question, there's no limitation in time. There is a case that says that if we become aware of a violation and then we fail to do anything about it, and then they act in reliance on our failure to do something, that creates a defense that's called estoppel or latches. So once we become aware of something, we kind of have an obligation to do something about it, or we potentially waive the city's ability to do something about it. But those are really the only considerations of when something's kind of long-standing, like what we have here. Is that more on point to your question?
I've heard of people like enclosing their lanais or putting an addition onto their house, and then after the fact, the HOA may complain to them or whatever, but because planning and development doesn't get involved because it's completed. Is that incorrect, or?
And that would be incorrect as far as my understanding of the law. I mean, if something is enclosed without permits, that it remains in that state until it's either removed or permitted.
So there's no time limit on that?
If the city, the case that recognized the estoppel defense, in that case, there was an accessory structure that was built in the backyard, and it was built into a setback, and the city didn't notice that, and they permitted the roof and they permitted the windows on that. And then later, they came along and they realized, oh, you're in the setback, you need to demolish this building. And the court said, well, you can't do that. You've inspected the windows, you've inspected the roof, you had your chance and you missed the opportunity to enforce the setback. And that sort of created this idea that there's an equitable estoppel defense for code enforcement. But that's not what we have here. I mean, you know, if we had been aware of these things and we allowed them and they invested more money into their property based on the idea that we were allowing it, then that would be a different situation. But just if we're not aware of it and it just takes a long time for us to become aware of it, that doesn't prevent the city from enforcing anything in that situation.
Thank you.
Thank you. Any other question? You're looking for a compliant state of when?
Oh, I didn't get there. Oh, okay, so for this violation, it is going to be for section 4-203.A.1 for permits required, specifically for the pavers that were laid on the common property without a permit. The property owner is here. He has been in compliance prior with a different violation. He was unaware of this today, so I do, now that he is here, he'd prefer I just speak on the behalf. I'm more than I'm confident that he will come in compliance. So, this is just another aerial view of the property, posting to the property. And this is the pavers that are laid in the back that will require the permitting. And these are just updated photos along the way for each notice that I sent out. So compliance could be met by obtaining an issued permit and completing out said permit or removing the pavers. And requesting compliance by obtaining a permit on and before March 25th, 2026, and completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Thank you. Any other questions, board? Can I get a first motion?
Mr. Chairman, I'll move to find the respondent in violation of the code as referred to in the affidavit in this case.
Can I get a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Can I get a second motion, please?
Mr. Chairman, I move to enter an order requiring the respondent to correct the violations on or before March 25th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Can I get a second?
Second.
All in favor?
Aye.
Aye.
All opposed? Motion carries. Moving on to 3.1 or 3.10, case 28-26, find respondent's proactive property management at 3404 Brigadoon in violation of code for permits and issue an order with compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese?
Okay, I'm Inspector Kat Reese at the City of Clearwater. This is going to be in reference to property 3404 Brigadoon Drive for property HOA 4400 Brigadoon Circle, code 20, case number 28-26. This is going to be for one violation, section 4-203.A.1 for permits required, specifically for the permits needed for the pavers on the common space property. First notice was sent April 11th of 2025, and the final was sent September of 2025. We did have a certified mailed sign. This is the property in question right here. That's my posting to the property, and it is for the pavers in the rear of the property beyond their property line. I have not had any communication with this property, compliance can be met by obtaining an issued permit and completing said permit or removing the pavers. Requesting compliance by obtaining a permit on or before March 25th, 2026, and completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
Board, do we have any questions? Can I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Can I get a second?
Second.
All right, all in favor?
Aye.
All opposed? Motion carries. Can I get a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before March 25th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Can I get a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
And we're going down to 3.14, Mr. Chairman.
Yes, I see that. 3.11 is continued to next month. 3.12 has been withdrawn. 3.13 is continued to March 25th. Our next case is 3.14, case 32-26. Fine respondents Brendan Ryan Buchanan at 4302 Brigadoon Circle in violation of code for permits, and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case? Inspector Reese, you have the floor.
Okay, Inspector Cat Reese with the City of Clearwater. This is going to, oh, I have the wrong one up, sorry. I don't want to redo it. 4302. This is going to be in reference to 4302 Brigadoon Circle. This is for case 32-26. This is going to be for a violation for permits required, section 4-203.A.1. Specifically, if a permit is required for the patio enclosures constructed on the property. First notice was sent April 22nd of 2025 and the final December 1st of 2025. Did have certified mail signed. This is going to be just here on the south end of the property. This is my notice that was posted. And this is the patio that's in violation. Compliance can be met by obtaining an issued permit and completing out said permit. I am requesting compliance by obtaining a permit on or before March 25th, 2026, and completion of permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist. I did have communication on this property way back in May. I gave him an extension so he can have time to get a survey. I just said, you know, just show some progress and we'll continue to work with you. The last I had spoke with the property owner was November, where he assured that he was still working on the survey. I have had no communication since then from him.
Was the patio enclosed when you talked to him, or hadn't been started, or what?
Well, this is after the fact work, so, and that will be all the patio enclosures there. They were not originally built that way. There's no permit on record, therefore it will need to be permitted.
I'm just amazed at people at Brigadoon. It seems to be the epic over there. They go ahead and do the work, and that's it.
Right, and the city's position is if there's a violation, we have to move forward with it to get them all permitted and in compliance. It is unfortunate. A lot of these people are taking on violations that they didn't do, but that is the case for almost any permit after the fact.
Okay.
Board, do we have any other questions? All right, can I get a first motion, please?
Mr. Chairman, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
All opposed? Motion carries. Can I get a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before March 25th. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Can I get a second?
Second.
All right, all in favor?
Aye.
All opposed? Motion carries. Moving Moving on to number 3.15 on our agenda, case 33-26. Find respondents Hannah Bakara and Madiha Ibrahim at 4004 Brigadoon Circle in violation of code for permits and issue an order with a compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case?
Man, nobody
Inspector
showed.
Reese, you have the floor.
I'm Inspector Kat Reese with the City of Clearwater. This is going to be for 4004 Brigadoon Circle, case 33-26. Oh.
I'm coming.
This is going to be for one violation for permits required, section 4-203.A.1, specifically for the patio enclosure constructed on the property requiring a permit. First notice was sent April 23rd of 2025. My final was sent September 3rd of 2025. Certified mail was signed May 12th of 2025. This is going to be the property in question here on the property. This is a posting. And this is the patio enclosure on this property. So as you can see, the enclosures vary depending on the property. I have had communication, my first time speaking with the property owner was May 1st of 2025. I provided him an extension so that way he can start the process of a survey and plans. I followed up with him in August. There was still no progress, same as in September. There's, again, no progress and no further communication from that point.
No communication since when?
Since
September?
September 19th.
Okay.
So unfortunately, yes, I have tried to work with some people, but, you know, if there's, at least show me a survey, something.
Yeah.
To show progress, and I would continue on from there, and let's work on the next step, you know? But at this point, the communication has stopped. So compliance can be met by obtaining an issued permit and completing said permit. I'm requesting compliance by obtaining a permit on or before March 25th, 2026, and completion of the permit 6 months from issuance of said permit. If the violation continues to exist, impose a fine of $150 per day each day the violation continues to exist.
All right. Board, do we have any questions? Can I get a first motion, please?
Maybe our two colleagues on the end would like to read one. We're going dry up here.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Can I get a second?
Second.
Second.
All right. All in favor?
Aye.
All opposed? Motion carries. Can I get a second motion, please?
I move to enter an order requiring the respondent to correct the violations on or before March 25th, 2026. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Can I get a second, please?
Second.
Second.
All in favor?
Aye.
All opposed? Motion carries. Moving on to case, our number 3.16 on the agenda, case 34-26. Find respondents William Black at 2390 Willow Tree Trail in violation of code for unsafe building and issue an order with the compliance deadline and fine if compliance is not met. Is there anyone here to speak on this case?
Yes,
Good day, sir. Could you approach and give us your name and address?
yes, William Black from 2390 Willow Tree Trail.
And what is you are the owner of the property, sir?
Yes, sir.
Okay, very good. If it's okay with you, we're going to listen to what the inspector has to say, and then we'll give you plenty of an opportunity to respond or provide us information.
Good afternoon, Board. My name is James Larson, Building Inspector, City of Clearwater. This is case number 34-26. We're not up there. Okay. So it's got one violation, property maintenance requirements, minimum building and fire code requirements. All buildings shall be maintained in accordance with the Florida Building Code, Section 3-1503, nuisances, existence of any of the following conditions, buildings which are abandoned, boarded up for a period of 6 months, partially destroyed for any period of time, or left for a period of time. Notice of violation is 5/9/24. Compliance date, we're asking certified mail returned unsigned on 6/11/24. That was before I took the case. Property was posted by myself on 2/13/26. You see he's here. Notice of hearing posted 2/13/26. This is my notice on his front door. Here's his location, the red spot. You see where it's near Top of the World, and it's east of Belcher, where it turns into Countryside Boulevard there. There's his house on the right. Front of the house, that's how it looked this morning when I was there. He has boarded up, as you see. This is what it looked like, I guess, the day of the fire. I wasn't there. Typically, the fire department provides us with these type of photographs. You can see it was quite a fire. Interior picture. Again, you see everything's covered in smoke. Another fire picture.
Fire.
It was a big fire. This is a Google Earth picture of the back of the house. For compliance, we met, have a licensed contractor obtaining complete required permitting for any repairs necessary. We are asking the board to authorize the city of Clearwater to enter onto the property to correct the violations by any means necessary and any reasonable cost to be applied as liens against the property. After 3 months from the recording date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Okay? It looks like a pretty big fire.
Yeah. Mr. Black, will you step forward, please? The first thing we need to ask you is, do you admit or deny the violation?
Admit.
Thank you. May I get a first motion, please?
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Can I get a second?
Second.
All in favor?
Aye.
All opposed? Motion carries. Mr. Black, what can you tell us?
Well, hold a permit to start the project. That would be this past Friday, a demo permit, interior. I have at this time, the county has I'm an applicant with the county for a grant for this property. And so that's active right now. But if I need to do it myself, I was trying to use that demo permit to bring in an electrical contractor, restore power, and I could stay at the property. Just mostly clean up. I have 2 rooms that are not affected.
Okay. Anything else, sir?
The permits are pulled and we're ready to start.
So you're staying at the property?
Not right now.
Okay,
Trying to restore power.
okay.
The water's on right now. It's been on for 2 years. I just had a delay to a cancer diagnosis, and I put my intention on that more so than the house. That was right at the same time. It burnt right after that started.
I'm sorry, what?
Well, the fire was about 2 weeks after my diagnosis.
I got
Over
you.
a month, so.
Did you, I'm just curious, what started the fire?
I wish I knew.
Okay.
I was away, I was at the store. I
Okay.
come back and I had 4 fire trucks. I'd really like to know myself. I go from carelessness to arson, you know.
I understand.
Board, do we have questions?
Well, I have a question. You're saying you have approved permits?
Yes, the starting permit, the demo.
Okay.
Is this I'm sorry to interject, is this an approved permit, or is it permit just been applied for?
Right.
That's the question.
I was told it was approved Friday, or, well, yesterday by one of your people.
Inspector?
I
Inspector,
just
you have
didn't
something?
receive an email.
Okay.
Yes.
He has an approved interior demo permit. At that point, he's going to require,
I'm looking to get a
Engineering.
licensed contractor in there to electrical,
Right.
then I can restore it.
So you're planning to do the interior demo and clean up yourself?
Yes. Well,
Okay.
my crew, yes.
Okay.
It's gonna take a while.
Inspector, I noticed your recommendation was to allow the city to go in and do what needs to be done, and yet Mr. Black has offered that he has a permit that's been approved for the interior demo. Would you care to speak to that?
that's kind of a standard verbiage from what I understand. Mr. Black recently got the permit. Him and I have been in contact a lot in the last 2 months, and I've been trying to help him to wrap his mind around keep getting the ball rolling, and that's what he's done. He just been in constant contact with me. He's trying to get this taken care of. He apparently has owned the home for many years, and
Okay, what is your position as a code enforcement officer, the city's position in terms of Mr. Black and his permit proceeding with the interior demo? Do you have an opinion about that? What I'm trying to do is reconcile your recommendation against the fact that I see Mr. Black has a permit and I see Mr. Garrett approaching. Perhaps he'd like to speak.
Yeah, if I can say a word or two. I'm Kevin Garrett, the building official for the city of Clearwater. The violation will still exist until everything is repaired. So the interior demo is to get the bad stuff, the burned stuff, everything that fell down out of the way so they can see really what needs. If, they need new trusses, they need new studs, whatever. But that's not going to stop the code violation there. Until that house is brought back into 100% code compliant living space, there's going to be a violation there. So this would just be a step one, having the demolition permit that will allow them to begin work. So there's more, going to be have more to come after this.
Oh, yeah.
Understood.
Thank you.
I understand that myself also.
Mhm.
I mean, this is to restore electric, so that's to expose electric behind the wall. This is the starting point. Yes, make sure
Correct.
safety and all.
And you could get a temporary power pole to get power there to work at it right now.
Right. Powering the pool is a good thing too. Power pole, I'm not just gonna plug in the pool pump, but, so.
Right, you could talk to the power company and apply for that permit and get that permit right now also. That would be another step you could take towards compliance.
Inspector, can I see your recommendations again? I want to make sure I've got my thinking clear on this one. So you're asking the board to authorize the city of Clearwater to enter onto the property and correct the violation by any means necessary, and have the city proceed. And what I'm seeing here, unless I'm not seeing this correctly, is the city is operating from the viewpoint you want to go in and do something, and yet Mr. Black has a permit.
A new permit.
Yeah, a new permit. So
Yeah, it's confusing.
Does that change your recommendation?
I would say it's not gonna change our recommendation. You know, if the work were done, if we saw the demolition, if we saw the other stuff repaired and replaced, that's what's gonna bring it into compliance.
But do we have some prior, we don't have a prior motion or order on this, do we?
No.
Because that sounds like a follow-up, not an additional, an initial
Right.
item to do when we've got somebody who's cooperating and is making some progress.
Agreed. Yeah.
I don't know off the top of my head if there are other cases or orders, so I can't speak to that.
So we don't know if there's a history to this particular case that's come before the board prior to today? Inspector?
I can speak to that
No,
real
sir.
quick. There are additional violations that have come to the board for this house before. Abandoned building was one of them. I know there's lot clearing. So it has come before you before for other violations.
Okay.
Okay, and I think notwithstanding that, the fact that we're seeing some progress here, I don't think that's the appropriate
Right.
Thank you.
item for us to be considering. So if the city feels differently, we need to hear that.
Well, I defer to the building official. I mean, they're the investigators out there, you know, with eyes on the situation for those things, so.
We can just.
Some of the transactions here on this property have happened very recently, so feel free to make your own recommendation and your own motion that would be more appropriate to the actual current state that we're in right now. This maybe isn't the proper way we should do it at this point.
I have a question for Mr. Black. How much time do you think you need to get the interior demolished now that you have a permit and reach a point where you can get some electrical there and show some progress?
Maybe that within 6 months, but the county it's not just an application. There's a case manager working with me. The county would like to, if they accept my case, they would like to take over my property and all involved.
When you say take over your property, what do you mean? Take over
It's a
ownership or
grant.
take over
It's
the
a grant to
construction?
rebuild my property.
All right, so they would provide
So
you,
I was gonna go forward regardless. That's why we need to start with a demo. So, you know, because I knew an electrical inspector had to come in and power it up.
So you're waiting to hear about a grant,
Yes. and
so
I'm
you can have the
currently
work
trying
done,
to
yeah.
Finish the application. It was specific information.
Have they give you, Mr. Black, any idea on how long it might take for them to grant you?
I have no idea, 'cause
Okay.
I don't work with the county or in government.
I mean, the case manager has brought that up to you?
He has contacted me since the application, maybe twice. I'm finishing the information. They like a lot of information, my health background, they like hospital records. So I'm just going through the process.
Yeah.
And right now, that's why partly I was going forward regardless with my, demo permit just to start.
are you,
I'm requesting the city for an inspection, but I'm not in the put-together phase right now when I was only awarded a demo permit.
okay. Are you able to move forward with the demolition and electrical things without the grant?
Yes,
Okay.
yeah,
Mr. Chair?
I think we can just finish the motion and just vote. If we all vote no, then it's gone away and they can just reapply sometime in the future.
Or we could set it down the road and look at
look at
the
it.
progress with the history on this, or history on the property, I think it would.
I have a question for Mr. Black. Mr. Black, how long do you think it will take your crew to do the interior demolition?
I think the demolition would be rather quick. You know, it's not restoring, it's not finishing, it's tearing out drywall. It's gonna expose some wiring. The water's running in the house right now.
Right,
A demo
okay,
So,
permit is good.
you know, I just gotta make sure the supply is coming through.
okay. So would a month give you enough time to do the interior demo?
It's about having people on the job. It's probably possible. I would look more in places like 6 months. Well, I'm looking to purchase windows and all that if I have to proceed and if there's no county involvement.
Right,
This is all just coming together at the same time.
okay,
But
So,
we're-
I was just gonna go forward regardless.
Well, we're talking about the demo.
Okay.
We're looking at the demo phase and what's a fair amount of time to accomplish that and see progress.
I think that's set by the permit, 6 months.
Well,
not necessarily.
Mr. Chairman, the counselor wanted to interject there.
If I may, thank you. I did just pull some of my files, and this case was originally brought to the board in April of last year, and then again in June of last year. There was an abandoned building violation that was heard in June of last year, and according to what was presented, it appears the fire occurred at the end of 2023. So that's just give you a timeline of the events. We also had a lot clearing and an inoperable vehicle case that went to the April meeting of last year. So that's just put that for you in terms of timeline.
And were the lot clearing and inoperable vehicle handled? Okay,
okay.
Yes, way back, and I
Yes.
lost the fence, yeah.
okay, thank you.
It's,
Okay.
it would seem that if we provide for a compliance date and then rely on the inspector and the owner to be in communication with one another to determine what happens after we make a ruling, then the inspector has some latitude on that in terms of when he brings it back or what he sees in terms of progress and what his next action would be
Okay,
in terms of,
yeah,
Time on that?
right.
yes, that's what I was thinking. 2 months?
60 days?
Yeah.
All
How about
right.
60 days?
Mr. Black, can you work with, if we allow 60 days for the demo? And the
Okay.
inspector will have some latitude to work with you on what happens next, but if we give you 60 days, is that some good time to get some work done?
Yes.
Very good.
Okay.
All right.
But can we enter an order like that with that recommendation on the
No,
table?
I think we're disregarding that because I think, if I'm reading this correctly, things have changed since that recommendation
Right.
was authored, in that there's now a demo permit in place.
Do we need another recommendation, or can we?
Yeah, we could
do it
withdraw
for-
that recommendation
Okay.
if that
All
is
right.
bothersome. We could withdraw that recommendation if that is bothersome, because the intent, when we put this together to come here today, was to get permission to tear it down.
Right.
Right.
And, things have transpired since then that we need to update.
Yes.
Thank you.
I would just request that we continue for 60 days if, based on that statement, and then we'll just come back before the board in
Make an
60 days,
appropriate
and the city will have an
recommendation.
updated recommendation at that time.
I like it.
Yep.
All right. May I have a motion,
We
please?
have someone
I'm
else who
sorry?
wants to say something.
Mr. Root.
Board, hi, I'm Dana Root, Assistant Building Official for the City of Clearwater. I would ask that you give some sort of definite timeline, because the neighbors, the citizens of Clearwater want a timeline on when this house is going to be fixed. So,
We were going to say 60 days.
continued though. That's not a timeline.
Yeah, I understand what you're saying, yeah, because it is unsafe.
Yeah.
And
Well,
it's not unsafe to drive by, I mean.
So the neighbors want an answer.
okay. If we provided continuance for 60 days and then get an update on that, and if it's not compliant with, or we don't see the progress, and at that point, revisit it and
Bring your
and move
recommendations.
forward in a different or tighter direction. Is that not satisfactory?
Jared, did you say the fire was in '23? Because our
According to-
notice went out in May of '24. So we're almost at 2 years here. We'll be at 2 years and, we'll be close to 2 years and 60 days. So that's why we're here.
Understood.
We just then heard about the Brigadoon that's 20 years old. so-
Yeah, there you go.
Well,
Well, that wasn't.
Anyway,
different,
I'm just saying,
Unsightly.
they should just come back.
different in that it was unknown about, and I understand that the time involved in the case, and I understand that Mr. Black's health issues as well, and so I will rely on the recommendations of the board.
Well, if we go 60 days, then that's going to be well over 2 years plus if there's more permitting to rebuild. So we're talking 3 years.
Well, how about an update in 30 days? Is the permits in place, and we would know within 30 days if there's progress moving, and if not, then revisit?
Mr. Chair, that would be my preference if I may. I mean, if I was not aware that the city has issued a permit to the property owner on this until today. And so I'd like, personally, would just like to have some time myself to confirm and take a closer look at that. I have a little bit of hesitation about the city entering onto private property and demolishing a structure that we have issued a permit to the property owner to repair. So I'd like to take a closer look at that if I may, and I understand Mr. Root's concern, and I do, in looking at my files, I do see that we have had quite a bit of correspondence from the neighborhood on this, so I don't want to disregard that either. So I would request for the 30-day continuance. That would give me a little bit more time to get up to speed on the latest developments of this before we request authorization to demolish it from the city.
Okay. Any other questions?
That's a good recommendation,
Any questions about that recommendation or any other recommendations other than that from the board?
No, we might want to consider next time doing an unsafe building order, setting the clock like that. That's something you can.
For this particular case, I mean, we have other cases where there's been fines and things. I think that was part of the conversation that we had in terms of seeking the demolition authority, is because we already have fines and liens on this property, and they have not been effective in remedying the situation. So the point of bringing this.
Reset the clock, basically. And say, we know you've made some progress here, but if you don't continue it, we're going to come in and take care of it ourselves. But that's for next, let's continue it for now. Consider that for later.
I think we could.
If we come back next month, I mean, we'll make whatever recommendation at that time, whether it's fines or if it's additional time until we're allowed to demolish or whatever. I'd like to meet with the building department. I'd like to see the permit that was issued. Personally, I'd like to get a little bit more comfortable with the latest developments before we move it forward.
All right. If we're to continue it for 30 days, then I'll need a motion.
I'd like to make a motion, that we continue this case for 30 days, till March 25th, 2026.
Second?
Second.
All right, all in favor?
Aye.
All opposed? Motion carries.
Good luck, Mr. Black.
Thank you. All right, I believe that concludes this section of our meeting. We're moving on to old business items, the affidavits of compliance. Madam Clerk, I believe we have taken all of these in one motion.
Yes.
We spell out, list verbally what those are, as there's a host of them here, and then make one motion to accept all of them. Is that correct? All right. So our next order of business is old business items, and that would be cases 4.11 through 4.1.12. Do I need to list these individually?
If you could read the case numbers, Chair, Mr. Chair.
All right. So we are going to rule on case 4.1.1. Do we need, Madam Clerk, do we need to,
If you could read the case numbers at least.
all right, you're talking about the PN?
Yes.
All right, all right. This next order of business will be acceptance of affidavits of compliance on cases PNU 2012-00570, case number PNU 2015-01039, case PNU 2013-02216, case 128-24, case 92-25, case 109-25, case 152-25, case 200-25, case 07-26, case 10-26, case 38-26, case 40-26. Can I get a motion to accept the affidavits of compliance?
I move to accept the affidavits of compliance as listed.
Can I get a second?
Second.
All in favor? Aye. All opposed? Affidavits are accepted. Next, we move on to our nuisance abatement lien filings. Case, or number 6.1, case 6-26 has been withdrawn. Case, or our number 6.2 has been withdrawn. Number 6.3 has been continued to March. So the next case here is 6.4, case 69-26. Accept the nuisance abatement lien for respondents Delbert and Mary Lou Baustart at 134 Brightwater Drive for lot clearing, and issue an order with the compliance deadline and authorize city to mitigate the violation if compliance is not met. Is there anyone here to speak to nuisance abatement filings on this?
Nope, think so.
Nope, okay, well, you can look up, I guess. All right, Inspector Maddox, you have the floor.
Good afternoon, Board. Kevin Maddox, Code Compliance Inspector for City of Clearwater. This is for case 69-26, 134 Brightwater Drive, a nuisance abatement. One violation for 1503B7, B8, and B5A, overgrowth right-of-way, overgrowth and accumulation of debris and trash. These are the dates of the violation, mailed and posted. Compliance date for the 16th of February, certified mail was received back but unsigned. This is the property straight on. It was posted on the 5th of February. This is the front area that's just dead and unmaintained. The rest of the property, it's kind of a hotel, if you will, but it's just not been maintained in a while. This is the 17th of February, again, in the same state, nothing has changed. All pictures kind of replicate the same thing. I had the pictures up there that were, I thought I had upgraded it, but today I went out there and again, the pictures were identical in being the same state that it is as of this morning. Compliance can be met for lot clearing by cutting all grass and vegetation to include the curb line, sidewalk, and continue to maintain it, removing all trash and debris and continuing to keep it clean. For recommendation for 69-26, requesting compliance 5 days after the board renders its order.
Inspector, can you go back to that picture one time, let me see the graphs? There we go. Okay, got you. And it looks like, is that a tree or a bush that's filled in?
It's like a dead bush that
Okay.
was about this big and
That's
just
what
fallen over.
I wasn't sure of. Okay, thank you.
Is this an ongoing business? Are there any occupants at this place, or is it just?
I don't know. I haven't had any contact with them. From the surrounding area, it appears to be a very small, old hotel that's just not being used. It could have been that way since the hurricane, but I happened to notice it and brought it up.
Thank you. Any other questions from the board? Can I get a motion, please?
I move to enter an order finding the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry onto the property, to abate and maintain the nuisance and charge the respondent with the reasonable costs which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Can I get a second?
Second.
All in favor?
Aye.
All opposed? Motion carries.
Thank you.
Moving on to case number 6.5, case 70-26, accept the nuisance abatement lien for respondents Chandra Ramnarian at 1475 Park Street for lot clearing, and issue an order with the compliance deadline and authorize the city to mitigate the violation if compliance is not met. Inspector Sudith, you have the floor.
Good afternoon, Vicki Sudeth with the City of Clearwater Code Inspector. This is for 1475 Park Street, case number 70-26. There's one violation here for trash and debris, code section 3-1503B7. Notice of violation was posted and mailed on February 4th of 2026 with a compliance date of 2/11/2026. Not received the certified mail. This is a copy of the posting on February 4th. There was a pile of trash out to the street, along with some tires, paint, gas cans, lots of other chemicals. I'm not quite sure what they were. There's also a bunch of tires. You can see some garbage cans there. I did reach out to solid waste as to if there was a reason why the garbage can was not being dumped, and they said that all the garbage cans there are contaminated with stuff that we cannot pick up, and that's why they continue to sit there. However, the tenants continue to put more stuff in them. This was again on February 11th. Nothing had changed, just more stuff added to it. Again on the 17th. And then this was this morning. Compliance can be met for the lot clearing by clearing all trash and debris from the property. Requesting compliance 5 days after the board renders its order.
Inspector, what is the litigants told you in their communication?
With the owner, I haven't heard from
Haven't heard
any of
from
them,
him?
and I've tried to make contact even with, it's a duplex. I've tried to, nothing from either or.
Okay.
Board, do we have any other questions? All right, can I get a motion, please?
I'll read the motion, Mr. Chairman. I move to enter an order to find the respondent in violation of code and requiring the respondent to correct the violations within 5 days of the board's written order. If the respondent does not comply within the time specified, the city may take all reasonable actions, including entry into the property, to abate and maintain the nuisance and charge the respondent with a reasonable cost, which will become a lien on the property. If costs, fines, and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
All
Aye.
opposed? Motion carries. Madam Clerk, are we hearing 6.6 or are we continuing
No,
it?
we'll
All right.
continue it.
Very good. Can I get a motion to continue case 71-26? To continue it until March 25th.
I'd like to make a motion to continue case 71-26 until March 25th, 2026.
Can I get a second?
Second.
All in favor? Aye.
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 All opposed? The motion carries. That concludes our meeting, and we are adjourned.
Good job, Bob.
I had a comment.
Good job.